Welcome to the third installment of the online gaming series on the Lex Prudence podcast. If you haven't heard the first two episodes, I will recommend you to please listen to them. And I'm sure the third episode after that will be even more interesting as you will have some background of what we are discussing on these episodes. Hello, all of you. My name is Amol Apte, and this is Lex Prudence podcast. If you haven't heard the content of this channel, please search Lex Lex Prudence Prudence on Spotify or Google Podcast and give it a try. There are some old episodes that I have shared on certain interesting legal issues and topics, and I'm sure you will enjoy them. As you're aware, this time round we are doing online gaming series and are trying to understand varied legal subjects surrounding the industry. In the past two episodes, we have tried to understand the different types of online gaming in India and then touched base with the first and the most important issue, that is legality of online gaming in India, in the second episode. In this episode, we will try and touch base with certain other legal issues around the online gaming industry. So, without any delay, let's just get into it. The first and the foremost area of law that concerns the OG or online gaming industry is tech law. Now, the first piece, when we say tech law, the first piece of legislation that comes to mind is Information Technology Act. And then along with it, the other piece of legislation that comes to our mind is data protection, or the DPDP Act as it is called now. Since we are discussing about online gaming as an industry, the Information Technology Act becomes one of the most important pieces of legislation. While the same does not deal with specific issues relating to online gaming, there are certain elements which a gaming company needs to be careful about, and then make sure that they are on the right side of the law and they are compliant with those certain provisions that are there are quite a few of them, but I will maybe quickly touch base upon certain provisions which may be relevant for the gaming industry more. So there's something like Section 66, which talks about the information which is offensive, false, or causing annoyance or inconvenience to public at large. Then there are specific provisions under Information Technology Act or IT Act that deal with it. There's obviously a host of provisions which are dealing with obscenity as a subject under Information Technology Act. And therefore, if you are a gaming content creator or an esports content creator, and there are possibilities of your content falling foul to the provisions of obscenity under the Information Technology Act, you need to be very careful about how you assess your game and how you publish your game. There are certain other provisions relating to uh, uh, use of unique identities of users, the personation related or impersonation related provisions, or dishonestly receiving any computer resource and those kind of provisions. I'm not going into the details, but in a nutshell, what I'm trying to say is that Information Technology Act is a single piece of legislation which deals with information technology as a subject. We being online gaming, it's important for us to look at those provisions and make sure that we are duly in compliance with. Obviously, there are other provisions also around fake news and larger provisions which are like threatening unity and integrity of India and those kind of subjects, which usually deal with fake news, etc. But then we have to make sure that we don't fall foul to any of those provisions. So that's first piece of legislation that we are looking at when it comes to the tech laws in the online gaming industry or an online gaming space. The other piece of legislation or other most important piece of legislation, which is a hot subject right now, is DPDP. What is DPDP? DPDP is the new avatar in which the Information Security or Data Protection Act or Data Protection Regime has been released in India. What is the full form of DPDP? It's Digital Personal Data Protection Act, 2023. It just came in the month of November 2023. What essentially this act has done is narrowed down the scope of the larger data protection piece to digital personal data protection. So it applies to the data handling, sharing, processing, etc. in the digital world. We being online gaming companies, it obviously applies to us. Now, there are about 26, 27 odd sections under the Act, and about 18 odd sections provide rule making power to the government, and the rules are still to be notified. But the Act is in force as of today. And what's more important, or what's more uh, key or necessary piece of information, is that the provisions under this Act are quite stringent. The penalties under this Act are very, very stringent. They go as high as 250 crore Indian rupees. And therefore, for all the companies, it's essential to look at their data collection processes, data processing processes, and all that they do with the user data. Now, just to dive a little deeper into this subject, and while we are discussing the subject of DPDP in detail, not in detail, in brief, but to get a better understanding of what this DPDP is, it actually deals with the subject of data protection through 3 or 4 major concepts. Now, what are those major concepts? First, data principle. Whose data principle? The person whose information is being shared. 2, data fiduciary. Someone who is collecting that data, storing that data, and using it for certain purposes. That's your data fiduciary. 3 is data processor. There may be data fiduciary itself who's processing the data also, but there may be third parties who are being used to process that data. And therefore, this concept of data processor also becomes important. The liabilities or the obligations of compliances are much higher on the data fiduciary than the data processor. But if you are a data fiduciary as well as data processor, then the obligations will increase manifold. Also, it becomes important for you to look at this from the point of view of all the contracts that you do with a lot of service providers to whom you hire for analyzing your data. The fourth important concept under this act is informed and express consent. So now the the concept of implied consent by the user is no more in existence. This act necessarily asks you to take informed and express consent from the user. What does it mean? The user has to be informed about what is the data that is getting collected, why it is getting collected, for what purposes this data is going to be used for, and then seek an express consent for all of that. If that process is not followed, you are obviously in breach. So again, it is important for you to look at all your product flows and product features and all data entry points from where the data is flowing into the company and see whether the consents are taken or no. The other thing that it talks about, or the major concept that it talks about, is the consent only for data that is required to be provided by the user for rendering of services. So now if you are collecting some data which is not important for you to provide the services per se, this act puts certain conditions or embargoes around that. So you have to be very careful as to what you collect, and how you take the consent. And then obviously the data deletion related concepts. So these are 5 or 6 major concepts. I'm not diving deeper into these concepts, but the data protection regime is here. It has heavy penalties, and the moment rules are notified under the act, you will have to start complying with it. It's time for you as a gaming company or a gaming operator to at least start doing those assessments to see where do you stand in terms of compliances on data protection or digital data protection regime, DPDP Act. The third important piece of legislation or a subordinate legislation is the intermediary guidelines issued under the Information Technology Act. Now, intermediary guidelines under Information Technology Act were introduced with two key objectives in mind. Now, what are those two key objectives? A, to provide a safe harbor to the entities which are acting merely as an intermediary. Now, what does that term intermediary mean? When the job of a platform is merely to bring transacting parties together and do certain things for and on behalf of those transacting parties, then that platform becomes an intermediary. Let's take an example of an e-commerce platform, which is a marketplace. What does that platform do? Brings buyer and seller together. And then those two entities are transacting on the platform. There are certain activities, obviously, the platform is doing, but those are done for and on behalf of the transacting entities. Now, therefore, it was identified that because platform is actually not doing the main job here, but is just bringing two entities together, there needs to be some sort of a safe harbor provided to them so that they are not held responsible for the acts of these two transacting parties. That's the first concept because of which the intermediary guidelines were released. Now, what is the second concept? The second concept is that when you are allowing a safe harbor to the entities to take as a defense against certain liabilities under Information Technology Act, you need to also create certain guidelines and guardrails which a platform needs to take. You create a governance structure so that only those entities which are duly following the governance structure and the guidelines and following the guardrails will get the benefit of safe harbor. That's the second concept. So first, a safe harbor needs to be given to somebody who is just a platform allowing transacting parties to transact. To that platform, in order to be able to get the benefit of safe harbor clause, needs to follow certain defined guidelines or create certain defined guardrails. And that's when they'll be eligible to get the safe harbor protection. Now, when we talk about these guardrails and guidelines, that's where the concepts of UGC, which is user generated content, then content moderation, then significant social media intermediary, then right to be forgotten, etc., come into picture. All these are the uh, concepts introduced by intermediary guidelines issued under the Information Technology Act. And I'm not delving deeper into it, but if anybody needs certain information around this subject, they can write into me and I'll try and answer as many queries as possible. So one needs to go through these guidelines from the point of view of assessment of the platform to see and make sure that you have the safe harbor available to you, because you are a gaming entity and what you essentially do is to bring two gamers together or two or more gamers together and allow them to participate on the games. Obviously there are certain things which you do originally for them, but then to the extent of the gaming activity only, you are an intermediary platform. So do that assessment and make sure that you have the safe harbor protection available to you. And the second thing that you need to do is to make sure that you are following all the guardrails or the guidelines prescribed so that that safe harbor protection remains available for you. So these two things are very important for you as a platform to do to make sure that you are duly protected under the law and from the stringent provisions of the Information Technology Act. Now, the third important piece in this tech law space is the amendments to intermediary guidelines, especially issued towards the online gaming industry. So last year, in the month of April, to be precise, on 6th of April 2023, an important amendment to the Information Technology Act, Intermediary Guidelines and Digital Media Ethics Code was brought in. This was one of the most important pieces of legislations for the online gaming industry. And why? Because it kind of gave a legal recognition, it kind of defined the governance structure to be followed by online gaming intermediaries. That's how the these guidelines call the gaming operators. Then brings in certain provisions for user protection and such other important areas which are very very critical for any fast growing and disruptive industry. And therefore I'm saying that this was the one of the most, if not the most important pieces of legislation that has come into picture for the online gaming industry. Now the key changes that were introduced to the intermediary guidelines through this amendment was a, and I'm just narrating few key amendments, I am not talking about all of them. So a, or the first one, is introduction of self-regulatory body SRB mechanism for better regulation of the industry. It's recognized that the industry should ideally be self-regulating itself. While there are guardrails again and guidelines prescribed under this amendment guideline, but the job of SRB will be to making sure that industry follows it in letter and spirit. So that's the first important piece that was introduced. The second important piece that was introduced in these amendments was introduction of concepts like online real money game. So now the RMG that we discussed in the first episode gets its legal definition. It also defines permissible online game. So the word permissible would indicate that there is some mechanism prescribed under these guidelines because of which a game becomes permissible online game. The third concept is permissible online real money game. So in the larger basket of online games, there's also something called as permissible online real money game. So again, the word permissible is important here. It also introduced an objective approach for assessment and certification of any and all games by the SRBs. So this permissible, so the permission to be permissible will be granted by SRBs, and the mechanism to do that certification will have to be devised by SRBs, which has to be objective and subjective, and combination of both will then kind of start that certification process or a licensing sort of a process. So that's another important piece of change that was introduced by the amendment to intermediary guidelines. The third important piece was introduction of key governance concepts like age gating, and I'm going to talk about the governance relating to online gaming in a separate episode. But what this introduces is the introduction of key governance concepts like age gating for users, user identification and verification. So basically introduces the KYC kind of a norm. And mind you, the guidelines actually at this point in time have prescribed the KYC norms equivalent to the banking industry as prescribed by RBI. So the gaming entities will have to start looking at their data very carefully, because at some point in time when these guidelines become effective, they'll have to start identifying and verifying the users. When it comes to identifying and verifying the user, it becomes important for you to collect certain documents: A, name; B, identification; C, age; D, address. All these things supported duly by the documents of provided by the user and verified by the platform will become the norm for the gaming industry. So that's the third important piece. SRB, all the concepts that it has introduced, and the governance. Now, while the appointment of SRB is still pending and therefore there's still some time for these to come into force, but let's hope that it comes into picture as soon as possible and it gives a due recognition to the industry, which is a fast growing industry in India. Now, other than these three or four that we discussed above, there are some more important guidelines and advisories like certain reporting, which comes into picture in case of data breaches, related matters are also there. But since we are discussing the pieces of legislation here and we are not getting into too much of details and legality, I'm not discussing those here. But somebody who wants to know can reach out to me and I will help you out with that. Uh, so that's about the tech laws around the gaming industry. We have kind of quickly touch based with some of the important laws around the areas of technology and data protection and got a brief sense on what lies ahead for the online gaming industry in terms of new laws and regulations that you need to keep an eye on. So, friends, we'll end our second episode of Lex Prudence Online Gaming series at this stage, and we'll catch up again next week with the next episode where we'll discuss various legal issues around the industry other than the legality and other than the tech laws now. We have covered legality, we have covered tech laws now, and we'll now start touch basing with certain other things like IP, financial laws, governance, as I said before, so on and so forth. If you have any questions, please do let me know through your comments. You can also write into me at lexprudence2020@gmail.com, and I'll definitely try and answer your queries. So catch up with you next Friday. Till then, take care. Namaskar.